Hello, I'm Edward Woodall, and I'm an attorney at the Venn Law Group. If you're like many of my clients, you've worked hard to start and grow your business. You've chosen good business partners, hired the right employees, and added new clients. But if you're thinking about buying property to expand your business, you need to understand the documents you'll sign at closing, the closing package. Closing is the fulfillment of a real estate purchase. While every deal is different, most commercial real estate transactions have the same set of documents in the closing package: the deed of trust, the promissory note, and the guarantee. In this video, I'll explain why each of these documents is part of the closing package and what each one does. Let's begin by talking about the deed. If you've ever bought a house, you'll be familiar with the deed. Every single real estate purchase includes a deed. The deed is what makes you the owner of the property. It needs to identify the buyer, the seller, and the property being conveyed. To be effective, it must be filed with the county government. In most transactions, borrowers need to borrow some of the purchase price from a lender. Loans can get very complicated very fast, but they all involve a promissory note. So, what does a promissory note do? First, a promissory note is evidence of your debt to the bank. Second, the note establishes many of the terms of the loan. Among the items which the note should include are the amount being borrowed, the interest rate, the frequency or schedule of payments, and what happens if you don't pay. Before signing, you should sit down with your attorney and read through the promissory note carefully to ensure that it conforms to the terms of the deal you negotiated with the bank, and to make sure there are no dangerous provisions hidden in the body of the note. Home buyers will also be familiar with the deed of trust. Commonly referred to as a mortgage, the deed of trust is the document you sign pledging the property you just bought as collateral for the loan. It allows the bank to foreclose on the property if you don't make payments or otherwise breach your agreement with the bank. For many commercial loans, the individuals behind the borrowing business entity will also be required to guarantee the loan. If you personally sign the guarantee, then you are on the hook if your business doesn't make its payments to the bank. If you have business partners, they'll likely have to sign guarantees as well. These guarantees are usually joint and several guarantees, which means that the bank can collect the full amount from any one of the guarantors instead of just your share of the debt. The guarantee is one of the most important documents in the closing package, but it's also often overlooked by borrowers as something just tacked on to the end of the deal. I covered a lot in this video, just by taking a brief look at the most common documents in a commercial real estate closing package: the deed, the promissory note, the deed of trust, and the guarantee. That's why competent, experienced counsel is key. At Venn Law Group, our real estate attorneys have decades of experience managing, negotiating, and closing deals of all shapes and sizes. To learn more about how we help our clients with closings and all other aspects of a real estate transaction, visit our Commercial Real Estate Practice Area's webpage.